Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I'm going to do a quick recap of the filings we read last night in the Justin Baldoni versus Blake Lively legal saga, and it was absolutely bonkers. As it turns out, there may be criminal charges coming for Stephanie Jones, and the New York Times apparently knew the text message evidence they were being given was possibly criminally obtained. They said no, and then they accepted the sham subpoena as a remedy. This stuff is absolutely wild, so let's get into it. We'll start with the revelations from the Abel filing. Jennifer Abel amended her counterclaims against Stephanie Jones. Abel was under the mistaken impression that by switching phone numbers, she had cut off Jones and JonesWorks' access to her text exchanges. Not so. In fact, Abel's text messages were tied to her iCloud, not her phone number, until Abel changed her iCloud password in January 2025 for unrelated reasons. Jones had been intercepting and monitoring all of her text exchanges, including not only with her clients, fiancé, doctors, parents, and friends, but also with the undersigned counsel. Indeed, the intrusion ceased only by happenstance during the pendency of this litigation. So until 3 months ago, Stephanie Jones was accessing Jennifer Abel's information, including her communications with her lawyers. Jones disclosed at least some of Abel's private communications to the Lively parties no later than August 21st, 2024. That's over a month before the sham lawsuit was even filed. Sloan, Lively's publicist, confirmed as much to Melissa and Nathan on a phone call that evening. These communications were drawn largely from Abel's iCloud, which was accessible through the confiscated iPhone. Despite lacking Abel's consent to access, review, or disseminate these communications, Jones and JonesWorks were able to do so without difficulty because, with the iPhone in hand, they could bypass the password protection that would otherwise bar their access. Shortly thereafter, Jones took things a step further and transmitted Abel's stolen communications directly to Sloan, Lively, and Reynolds. At the time, Lively was reeling from a storm of negative publicity. Devoid of scruples concerning the unlawful means by which Jones obtained the communications, and desperate for a scapegoat for Lively's bad press, the Lively parties likely saw a unique opportunity. While the contents of Abel's communications do not support the existence of an untraceable smear campaign, they do show that by the time of the film's premiere, Abel and others in Wayfarer's circle held Lively in deep disdain and, to a certain extent, relished in her self-immolation. These sentiments were the natural result of the Wayfarer party's first-hand knowledge of Lively's vicious behavior and malignant persona. In turning over these material to the Lively parties, Jones knew full well how they would be used, with slicing, dicing, cherry-picking, massaging, and in some cases outright alteration. The Lively parties exploited Abel's text messages to great effect. Joining forces with the New York Times, the Lively parties commissioned the hit. However, for different reasons, the Lively parties on the one hand, and Jones and JonesWorks on the other, needed to create a veneer of legitimacy. The Lively parties likely anticipated or were told directly that the New York Times would not traffic in stolen communications under these circumstances and needed the color of law. Jones and JonesWorks, for their part, wanted to insulate themselves from legal exposure to Wayfarer for breaches of confidentiality. Accordingly, on September 27, 2024, working hand in glove with Jones and JonesWorks, the Lively parties and their counsel at Mannett, Phelps, and Phillips initiated a sham legal proceeding in New York State Court, Vanzen Inc. versus Doe's 1 through 10. The sham lawsuit was nothing more than a transparent ploy to obtain subpoena power. The plaintiff, Vanzen Inc., is an inactive corporate entity affiliated with Lively and Reynolds and entirely unrelated to the film of the Wayfarer parties. The lawsuit asserts 3 causes of action: breach of contract, breach of implied covenant of good faith and fair dealing, and faithless servant against Doe defendant only. The lawsuit does not explain how or why Vanzen was unable to identify the proper defendants, especially in the context of a breach of contract action. Instead, Vanzen and Mannett impossibly claim not to be privy to the identities of its own contractual counterparties or its own employees, contractors, agents, or representatives. The lawsuit is devoid of specific allegations against anyone, much less Abel, relying exclusively on generalized recitations of boilerplate legal jargon. Notably, Vanzen never requested the assignment of a judge, substituted the Doe defendants for named parties, or served the complaint on any defendant. The only docket entries are the complaint and a notice of dismissal filed on December 19, 2024, the day before Lively filed her CRD complaint against the Wayfarer parties. The same day the lawsuit was filed, September 27, 2024, Jones warned a departing employee not to work for Abel because her business wouldn't be around much longer. Once the lawsuit was filed, the Lively parties used it to issue a subpoena to JonesWorks for all data stored on Abel's phone, including private communications from her iCloud and email accounts, as well as potentially privileged information. Since there were no identifiable parties and no party had been served, the subpoenas were issued without notice, depriving Abel of any knowledge of the subpoena, much less the opportunity to object. Plaintiff is informed and believed, and based thereon alleges that the sham lawsuit was contrived by the Lively parties and Jones, acting in concert to facilitate and cover up Jones' release of the data extracted from Abel's phone and personal accounts under the guise of legal process, without risking detection by interested parties, such as Abel, who could have intervened and stopped the flagrant abuse of process. As planned by the parties, upon receipt of the sham subpoena on or about October 1st, Jones and JonesWorks blithely surrendered the entire contents of Abel's iPhone communications for a second time, creating a veneer of legitimacy and affording Jones and JonesWorks plausible deniability once the New York Times came through for Lively. It is on this pretext that Jones and JonesWorks counsel later described responding to a court-ordered subpoena. As a result of Jones' malicious scheme, Abel's life has been turned upside down. Her career and reputation have been destroyed, her private information leaked, and her email inbox on social media pages filled with a daily stream of death threats and abuse. The backlash against Wayfarer and Baldoni has been equally devastating, with Baldoni wrongfully labeled as a sex pest, his accolades rescinded, and his future projects thrown into doubt. Abel lives in fear of what's to come, given the vast troves of personal data in the possession of these hostile actors. And looking at the causes of action, we can see they've added violation of the Computer Fraud and Abuse Act, violations of Stored Communications Act, violations of the Federal Wiretap Act, and those are among 10 separate causes of action. Now, taking a quick look at some of the new things that came up in the Wayfarer party's amended counterclaims against Stephanie Jones. Upon information and belief, the Lively parties anticipated or were told directly that the New York Times would not traffic in stolen communications under these circumstances and needed the color of law. Jones and JonesWorks, for their part, wanted to insulate themselves from legal exposure to Wayfarer for breaches of confidentiality. In December 2024, the Wayfarer team finally learned the magnitude of Jones' betrayal as a result of Jones' deliberate and unlawful disclosure of their private information, which Lively's team exploited to concoct a false and disturbing narrative about them. Wayfarer and Baldoni have been irrevocably harmed. Following the coordinated drop of Lively's fantastical CRD complaint and an explosive New York Times article, Wayfarer and Baldoni became objects of public scorn and derision. This stuff just gets worse and worse, guys. As always, I'm going to drop a link to the documents below so you can read them in full. But what's even worse is Blake Lively's speech at the Time 100 Summit tonight, which happened concurrently with the drop of these documents. I'll have more on that for you later, as well as what Stephanie Jones' attorneys had to say to the press. See you all soon.